Thank you, Martha, and I'll echo the thanks that you were given earlier. You were awesome. It was good to have you in the leadership role. Mr. Video Guy, am I on here? You got me? Okay. All right, well, welcome everybody. Second Amendment. Took a long time before we got some clarity on that. In 2008, there was a major Supreme Court case that interpreted the Second Amendment, said some of the things that it was, some of the things that it might not be. And that's what I'm going to talk about tonight. Here's the topics. Do a little introduction. We're going to go over the Second Amendment itself, and then the case, District of Columbia versus Heller, in some detail. And that was the reading assignment for today, by the way. And did anybody read the case beforehand? All right. Yeah, it looks like 20 people or so. That's good. Does it apply to the states or not? Because District of Columbia versus Heller was only about the federal government and federal gun legislation. So we'll find out if Washington's affected, or maybe a state like Illinois. I'm going to do a very brief review of lethal force and self-defense, because when I talked to the Tea Party guys about this topic, the Second Amendment, I said, well, what do you want to know, or what do you want to learn about? And it was invariably, who can I shoot? So I'm going to answer that. The answer is nobody. Then, as far as gun control goes, the District of Columbia versus Heller case is somewhat helpful for that. Somewhat not helpful for gun control. But I think what I'm going to do tonight is just go over some of the basics about gun control, some of the basic terms that you'll hear in the news, so you can understand. So the idea is you got these basic terms about gun control. You know the constitutional law. So in the future, you'll be able to do your own constitutional analysis when these gun control laws come up. Then we'll have the Q&A. I'm expecting that the Q&A will be extremely lively tonight. It always is, but I think especially tonight. So about me, this is our law firm. And it's me and my lovely and beautiful and awesome wife, Andrea. I need to talk louder. Is everybody here? Okay. I get this microphone right by my mouth. Okay. And this is the area of law that we do. Okay, the Second Amendment itself. Here's the text. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. We're going to go over that phrase in fairly excruciating detail tonight, although not nearly as much as Justice Scalia did in the 65-page opinion. Okay? We'll go over it some. I'm going to do a summary. But it's been pretty controversial, especially because it starts with this first phrase, a well-regulated militia. And we don't really have a militia today, so the question is, does it really apply? We split it up into two parts, a well-regulated militia being necessary to the security of a free state. That we'll call the prefatory clause. I think lawyers across the land learned the word prefatory in 2008. When Scalia talked about this prefatory clause, I had never heard that word before. But anyway, he calls that the prefatory clause, and then the other part is the operative clause, the part about not infringing the rights. Okay, so he splits that up into two parts. We'll see how that's important later. About this case, no offense, Mr. Turner, Sheriff Turner, excuse me. I'm sure he's heard that before. There are some major constitutional law concepts that are implicated in Heller, and it's pretty interesting. I mean, even the constitutional law professors, these are the things that they argue about, these topics. Some of these topics I've talked about before when we've done little constitutional law lectures here at the Tea Party. And they're all in the Heller decision. So if you read it, you really got a good introduction to some of these things. Incorporation, that was in another case which I didn't assign tonight, McDonald. We'll talk about that though. So here's the list of the constitutional law, theories or different areas where you can analyze the Constitution. Just going to highlight these here real quick. We'll go over the Heller case, and then at the end, we'll revisit these. Federalism. Federalism is the concept that we have a separation between the federal government, which is the sovereign over the entire continent, land, the nation, and then we have each state, and they have their own sovereignty over their own territories and their own people. And there's a mix. Some things the federal government has plenary or total power of, and some things are reserved to the states under the 10th Amendment. It's a Tea Party favorite. Enumerated powers. This is a concept that the federal government is only granted the powers that are enumerated, or in other words, listed in the Constitution. The idea that the founders had was, well, look, if we don't give you that power, you don't have it. Originalism versus the living Constitution. Well, Justice Scalia is known as the major originalist judge, and you got to say that this case, District of Columbia versus Heller, is the ultimate originalist decision, and we'll see. Stare decisis. This is a legal term saying if the courts have decided things in the past, we're not going to just overturn those decisions willy-nilly. The precedent is important. Even if we don't agree with it anymore, we should still respect the precedent. Judicial restraint and judicial activism. This is implicated in Heller too. In some ways, Scalia showed restraint. He didn't decide more than he needed to. But on the other hand, he was activist because he kind of spouted off about things that maybe he shouldn't have. And then incorporation, this is the concept, do these federal rights in the Bill of Rights, which obviously is in the federal Constitution, do those apply to the states? So it's not incorporated in terms like Xerox Incorporated or Microsoft Incorporated. It's not that. It's incorporated meaning does it apply? Do the federal rights apply to the states? Do they restrict state power or not? Okay. So District of Columbia versus Heller. What was the law about that was challenged? Well, the District of Columbia, which is a federal territory, it's under federal government purview there. They had prohibited handguns because you have to get a license for all your firearms. You can't carry a firearm unless it's registered. But guess what? They don't let you register any handguns. So it's not like they made handguns illegal. It was kind of, indirect or backwards. But in effect, it was a complete prohibition on handguns. And then not only that, they had this extra part. Even if you had the licensed gun that was legal, which of course it had to be a long gun, it had to be rendered inoperative. So you had to have a trigger lock, or the gun had to be taken apart, or something like that. Okay, that was the law in the District of Columbia. So we got this plaintiff, old Mr. Heller. He lived in the District of Columbia for many years. He was a security guard. So the cool thing about him in terms of his qualifications to be a plaintiff is that when he was at work at the federal building, he was allowed to carry a gun. But as soon as he stepped outside of work or went home, he was just like a regular citizen of DC. He was not allowed to have a gun. He applied for a license for his revolver, but he was denied. After he was denied, then he went to court. This is his